Yes, I'm Charles Kolano. I'm speaking against motion 11.1 the business paper. I raised some concerns as to some of the unintentional potential consequences if this motion is passed. These being legal ramifications, financial impact on the community, further deterioration of mutual respect between council and the community, and council's reputation. In the legal side, has competent legal advice been sought in this matter, and have all councillors been advised of this advice? Council already has legal means to deal with poor behaviour towards staff and councillors, as do the community against council. Why add another layer to this process? Where can the definitions for the terms threaten, intimidate, harass and humiliate, etc. be found? Are they on the SMRC website? Or are they, for example, in the Crimes Act of New South Wales? If the latter, this is my view, it becomes a police matter and should be directed to police and not using untold ratepayers' monies to feed the legal appetite. As already stated, council has the means to deal with poor behaviour. Financial. The community is against the wall with increased costs of living, rate hikes, council rate rises, food, fuel, etc. Where is the cost-benefit analysis for this proposal? This motion proposes that legal expenses will be allocated on an as-needed basis. Is this prudent decision-making? Following on from some council's previous decision, including a summary of costs in the February 2018 business paper, which shows council spent over $62,000 on legal costs, was awarded $48,000 odd, but spent another $40,000 pursuing this money. So the total cost to the community or council is $54,943.17. For what? It is noted all legal matters are now under confidential without community scrutiny. So basically you can do as you please. Another example is in the business paper of September 2019, which states, while costs have not yet been determined, it is assumed that the cost to either construct the existing road to a council standard would be considerable. How considerable were these costs? Why aren't we told what the costs are? Deterioration of mutual respect. This motion will, in my view, accelerate a further decline in respect between the community and council. Surely the position should be reversed so that council can be seen to supporting free speech in the community and accepting commentary from the wider community, be it either positive or negative. There is a saying, respect is earned and cannot be demanded. Council's reputation. Why are the community not afforded the same treatment by council as the councillors and council staff? In the New South Wales Court of Appeals in C1 v Vestio and Broder 2018 involving a barking dogs case, the judgment stated that the case should have been against the council, not council employees. It appears from this judgment that councillors and council staff are offered protection against things they say or do, and also what they do not do. Contrast the above with the following. A letter was sent to council on 1 August 2023 regarding the death of a calf following the sighting of 2 roaming dogs on a property. Although council has a communication policy, there's been no response. Why not? Or could it be in council's position that, and I quote, no further correspondence will be undertaken in this issue, as stated in a letter to me? Is this not a form of censorship or even intimidation? Does this action of failing to respond cause harm to council's reputation? Let's work together, respecting each other and listening to others' views, and sort out the problems without the threat of legal action. Finally, the allegation contained in the business paper, is it true? An accurate record of the events as published, namely that a senior staff member and family were threatened, intimidated, harassed, humiliated, etc. And if so, were the police called and the person charged with these offences? Surely council has policies in place to deal with this now. Thank you.
Thank you, Mr. Klein.
Charles.
Should we have Jason? Have Jason on the call? No?